Now, I'd like to invite Judge Jin-Hyun PAIK, the International Tribunal for the Law of the Sea, to the stage for his keynote speech. So Judge PAIK, please come to the stage.
Dear colleagues, dear participants, I'm honored to deliver a keynote speech again in the annual International Conference on the Law of the Sea, hosted by Ministry of Foreign Affairs of Korea, in cooperation with Korean Society of International Law and the International Tribunal for the Law of the Sea. I want to thank the organizers for a kind invitation. This year's conference, as I understand it, is the fifth of those which the Korean Ministry of Foreign Affairs and ICLS have been jointly organizing annually since 2018, and it is also their second collaboration this year. In September, the inaugural ICLS workshop for legal advisors was held in the premises of ICLS in Hamburg. The workshop was organized by the Tribunal with the generous financial support of the government of Korea. 18 representatives from Southeast Asia and the Pacific Small Island developing states participated in the one-week-long workshop. I attended the workshop together with some of my colleagues and had a wonderful opportunity to discuss with participants on wide-ranging issues relating to the law of the sea and peaceful settlement of disputes. This event, as well as today's conference, shows the strong commitment and support of Korea to the work of the Tribunal, and I want to express my deep appreciation to the Ministry of Foreign Affairs of Korea for its continuous contribution to the capacity building program of the Tribunal. Dear colleagues, 4 decades ago, in 1982, United Nations Convention on the Law of the Sea was adopted after almost a decade of strenuous negotiations to establish a new comprehensive legal order for the world's oceans. As the preamble of the convention declares, what the states parties aimed at achieving in their endeavor was to establish a legal order for the seas and oceans. The convention was thus intended to constitute the foundation of the comprehensive legal order for the world's oceans. Now, 4 decades later, what is the state of such legal order established by the convention? How effective has this legal order been in facilitating international communication and promoting the peaceful uses of the seas and oceans, the equitable and efficient utilization of their resources, the conservation of their living resources, and the study, protection, and preservation of the marine environment? What challenge is this order currently faced with? These questions, at least some of them, I believe, will be addressed today and the next 2 days under the theme of the conference, Law of the Sea for the Next Generation, Effectiveness of UNCLOS Revisited. Today I will briefly overview the current state of the legal order established by the Convention. Obviously, it is one thing to adopt the Convention, and it is something else to ensure its effectiveness. It would be naive to suppose that the adoption of the Convention would automatically lead to the effective functioning of the legal order it intended to establish. Generally speaking, an effective legal order requires at least 3 elements. First, there should be a well-developed body of laws. Second, there should be a well-developed body of institutions to implement, apply, and enforce such laws. And third, there should be a positive attitude of the members of the community toward laws, in the sense of members' commitment and willingness to comply with them. These elements are, of course, interrelated. However, only when all three requirements are satisfied and synchronized with each other, we can expect the legal order to function effectively. Let me elaborate a little bit further. The first requirement for an effective legal order is the existence of a well-developed body of laws. Such law must be general, clear, and made in public and in a democratic manner. In this regard, I can point out that the law of sea is one of the best codified branches of international law. Of course, the convention is the centerpiece of the law of the sea. It covers almost every aspect of the use and protection of the ocean. In addition, the convention incorporates various other rules, standards, and procedures developed elsewhere into its ambit. Furthermore, the fact that the process of negotiating and adopting the convention was democratic, with the active participation and substantial contribution of large number of newly independent states, has further strengthened the value and acceptability of the convention as legal norms. On the other hand, many provisions of the convention are often criticized for being vague and overly general. The lack of precision was to some extent inevitable, as the convention was a product of compromise based on a delicate balance between conflicting interests among states. However, at least so far, this has not been a serious source of instability. In addition, the pronouncements of international courts and tribunals have helped clarify the content and scope of some important principles and notions of the convention. The second requirement is a well-developed body of institutions. Generally speaking, this is an area where international legal system is relatively underdeveloped and weak compared with national legal systems. However, I think that UNCLOS regime may be more advanced than most other areas of international law in this respect. For example, the convention established the three major institutions to facilitate and ensure the implementation of the relevant provisions of the convention. While each of these institutions may have its own shortcomings, and there may be something to be improved, I believe that overall they have evolved and served their purposes satisfactorily without major malfunction. In addition to them, various other organizations, such as United Nations, International Maritime Organization, Food and Agriculture Organization, and UN Environmental Program, just to name a few, play their parts in ensuring the effective implementation of the provision of the Convention. In particular, the comprehensive system of dispute settlement with compulsory procedure, one of the major innovations of the Convention, and which has been widely utilized so far, has been instrumental to making UNCLOS the regime with teeth. The third requirement for an effective legal order is the positive attitude of members of the community, that is to say, the attitude of states toward UNCLOS regime. Ultimately, the effectiveness of any legal system depends on the attitude of states. whether states are committed and willing to comply with the rules in good faith. That is the key question. Despite all the progress made in law and institution, if states do not take law seriously, we can hardly expect the legal system to function effectively. Obviously, it's not an easy task to measure the attitude of states. There may be several factors in assessing such attitude, such as the number of treaties and agreements to which a state is a party, the level of participation in international institutions, or its willingness to submit disputes to international courts or tribunals. There are some positive indications in this regard. For example, I can note that maritime disputes have frequently been submitted to international courts and tribunals. In fact, in the past 3 decades, maritime disputes has been the most popular subject of international adjudication, only next to trade disputes. However, what may be more important than those indicators is whether a state recognizes and respects international law in its everyday interaction with other states. I think that as far as ocean affairs are concerned, international legal consideration has now become embedded in the decision-making of many states in their relations with other states. States may have different views as to the interpretation or application of the provision of the convention, but it is worth noting that many states refer to and rely on the provisions of convention to explain or justify their actions one way or another. At the same time, one cannot fail to notice some troubling trends in this regard. State practice in various areas consistently deviates from the provisions of the convention. Some states refuse to appear before international court and tribunals, and even openly defy their decisions. More fundamentally, we have lately seen the blatant disregard for the most fundamental rule of international law. The law of sea does not exist in isolation. The UNCLOS regime is part of broader international legal order, and as such, it cannot be free from the dominant trend of the time. I just wonder what would be the impact of such disconcerting developments to the international rule of law in general and the UNCLOS regime in particular. Thus, as far as the third requirement is concerned, the picture is not entirely positive, but rather mixed with the potential dangers lurking. Dear participants, dear colleagues, overall, 40 years after its adoption, it is my assessment that the legal order created by the Convention has worked in promoting the rule of law at sea. The Convention has almost achieved universality. Since its adoption, 2 additional implementing agreements have been adopted and entered into force, and third is currently under negotiation and is about to be adopted. Various rules and standards developed in other international organizations and agencies have been incorporated into the Convention regime. The UNCLOS institutions have steadily evolved to perform the roles that had been expected of them. If I put the development of UNCLOS regime of the past decades in perspective, I would say that the law of sea has expanded and elaborated. Its institutions have strengthened, and the UNCLOS system has matured significantly. This does not mean there is no problem, challenge, or practice that deviates from the provisions of the Convention. There are many. Often, tension arises and conflicts break out. However, the Convention has been successful in creating the expectation among states that the rule of law exists and operates across the world's ocean, and that justice can be done for all states, big or small, strong or weak, developed or developing. As the Convention ages, the inevitable question that will arise is, I believe many of us should reflect on, whether the Convention, which was a product of political, economic, scientific, and technological conditions of 1970s and early 1980s, can remain relevant to today's changed circumstances. This is the kind of question that can arise for any international agreement, but it may be more pressing for the Convention, not least in light of the close relationship with science and technology. Of course, technological innovation did not stop with the adoption of the Convention. On the contrary, technological developments have further accelerated since the adoption of the Convention and will continue to do so in the future. In fact, the drafters of the Convention were well aware of the challenges that lay ahead of the Convention which they negotiated. They expected that the circumstances and context in which the Convention operates would inevitably change, and this could seriously affect the relevance and viability of the Convention. They thus found it necessary to draft the Convention in such a way that it could adapt to subsequent changes and developments. Looking back the past 4 decades, I believe that the UNCLOS has adapted and adapted successfully. It has been relevant to a broad range of issues that simply were not conceived of or anticipated at the time of its adoption, and it will continue to evolve in such a way to be able to meet new challenges such as climate change and the protection of marine biodiversity. This does not mean that there will be no limit to the evolution of the Convention. As an international treaty based on the package deal, the Convention may not evolve beyond the fundamental ideas and principles underlying such deal. Therefore, the biggest challenge to UNCLOS in the future will be how to maintain hard-won compromise which the Third UN Conference on the Law of Sea had managed to achieve while adapting to changing needs and circumstances. Dear participants and dear colleagues, allow me to say a few words about the role of ICLS in safeguarding and enhancing the effectiveness of legal order established by the Convention. The Tribunal has a unique character in the Convention regime. While it is not the only court to deal with disputes arising from the Convention, ICLS is the only permanent judicial institution created by the Convention with wide-ranging functions, some of which no other forums under Article 287 of the Convention can perform. In other words, it is irreplaceable in the effective functioning of the legal system created by the Convention. The Tribunal, of course, deals with interstate disputes concerning the interpretation or application of the Convention. No doubt, the exercise of contentious jurisdiction is a primary function of the Tribunal, but its role goes far beyond that. The Tribunal and its seabed dispute chamber can give advisory opinions. An advisory opinion of the chamber is given to assist the work of International Seabed Authority, another important institution created by the convention to implement the concept of common heritage of mankind. While the convention does not contain an explicit provision for the advisory opinion of the full tribunal, Article 21 of the Statute of the Tribunal provides for the basis of such opinion. I know there are some different views about the advisory function of the tribunal, but I believe that the advisory function of the tribunal will prove to be material in enhancing the effectiveness of UNCLOS regime in the years to come. In addition, the tribunal has virtually exclusive jurisdiction to conduct prompt release proceedings under Article 292 of the Convention, which has been instrumental in safeguarding the interest of maritime states from the extension of coastal state jurisdiction under the Convention. Another unique role the tribunal plays is to facilitate the functioning of Annex 7 Arbitral Tribunal by conducting provisional measure proceedings under Article 290, paragraph 5 of the Convention. The tribunal's seabed dispute chamber deserves some attention here. This chamber has compulsory and near-exclusive jurisdiction over disputes arising from activities in the area, namely disputes concerning seabed mining activities. It should be noted that the chamber has competence to deal with disputes involving not only states, but also non-state entities such as International Seabed Authority, the enterprise, and natural and juridical persons. This represents a major innovation in international adjudication. When commercial mining begins, the Seabed Disputes Chamber is expected to play a catalyst in ensuring the effective functioning of the seabed mining regime envisaged in the Convention. While the primary function of the tribunal is to settle a specific dispute submitted to it, the tribunal in so doing develops and elaborates the law of sea set out in the Convention. The tribunal, as permanent standing judicial institution created by the Convention, takes this role particularly seriously. As I said earlier, the Convention provides for a broad legal framework for regulating the conduct of states in the ocean, but lacks specificity in many respects. Furthermore, the Convention contains many inherently ambiguous provisions. The Tribunal's role in the development and elaboration of such provisions by consistently interpreting and applying them to specific situations of cases before it is therefore crucial to the strengthening of the legal order established by the Convention. The Tribunal is well aware of the need and fully committed to the responsibility to safeguard the fine balance achieved in the Convention through its jurisprudence. In fact, I would like to underscore that such institutional responsibility makes the Tribunal distinct from other means under Article 287 of the Convention. The Tribunal is also fully aware of the fact that it has no exclusive jurisdiction over disputes concerning the interpretation or application of the Convention. The Tribunal recognizes and respects the freedom of states, parties, to choose their preferred means and endeavors to make the system created by the Convention work without increasing the risk of fragmentation. Its jurisprudence demonstrates that it has taken particular care to promote the uniformity and coherence of the Convention. In closing, I want to underscore that ICLS has special responsibility to ensure that the legal system created by the Convention works effectively without increasing the risk of fragmentation. I hope you agree with me that the Tribunal has so far successfully discharged this responsibility. I would like to thank you again for the opportunity to be here today, and I look forward to the lively discussion that I'm sure will take place during the course of the conference. Thank you very much for your kind attention.
Judge Beck, thank you for your keynote speech.